Breaking news, a plea deal by the former son-in-law of Paul Manafort, the one-time chairman of the Donald Trump presidential campaign. Let's get some more with our specialists and our analysts. And Laura Coates, what do you think? Because it does underscore the scope. There's the Robert Mueller investigation here in Washington, the Southern District of New York, the U.S. attorney there now investigating Michael Cohen, and now out in L.A., the U.S. attorney investigating the former son-in-law of Paul Manafort.
Well, from coast to coast, Mueller has a very wide net that he can cast and he can use to manipulate situations in a way that's lawful. He can have people try to cooperate in his endeavors and try to apply pressure to people like Paul Manafort. Yochai is the former son-in-law, divorced just in August. But as of last June, Mueller was sending people out to investigate and interview Yochai about his very close business ties to Paul Manafort. That's very important to consider because he is somebody who'd have information on different loan operations, loans for properties in New York and other places. He even lived in one of the places that allegedly may be a source of the investigation for Mueller. So he has a lot of information. And also, for one of the first times, we knew that Rick Gates was cooperating, presumably against Paul Manafort. As his right-hand man, he'd have a lot of information. Now you have somebody who we don't know what the relationship was like between Yochai and his former now father-in-law. Perhaps there's a vendetta or an axe to grind, perhaps something more they can use. But remember, the actual plea agreement, we're not quite sure whether he is specifically bound to cooperate in the Mueller probe against Manafort. He just must cooperate with other investigations, likely this one.
Gloria, Rudy Giuliani, the president's attorney, he's doing a lot of talking right now. What's his strategy?
Well, I'm not so sure there's a strategy in the sense of the word that we know it. I think Rudy Giuliani is out there freelancing an awful lot. I was told by a source familiar with the legal team that they're very happy he's out there freelancing because it's been cathartic for the president to have him out there. Doesn't help him much with Bob Mueller right now, the special counsel, but Rudy Giuliani is out there doing what the president wants him to do. But in terms of the question and the story that Dana broke yesterday about whether you can indict a sitting president and getting a direct answer, I think he wanted it out there for one reason, and that is that his legal team believes that you can therefore, and you're the lawyer here, I'm not, that you can therefore not subpoena the president to testify if he cannot be charged with a crime. So say they were going to be talking about obstruction. Well, why would you have to know his state of mind, for example, if you're never going to charge him with it? This will be one of the arguments, clearly, that they would make if Bob Mueller wants him to testify.
How do you see it, Ryan?
Well, first thing is, if it is true that Mueller has decided that you cannot indict the president, that is very, very newsworthy, because both the prosecutor in Watergate and Ken Starr, with respect to Bill Clinton, both believe that you could indeed indict a sitting president. And there are plenty of legal scholars that think you can. Remember, there's nothing in the Constitution that says you can't indict a president. There's no court that has ever ruled that. This is just a legal theory, right? It's completely unsettled. So the fact that Mueller has broken with his predecessors who were contemplating this question is a big deal if it's true, if what Rudy is saying is true. And I think Rudy's strategy is he wants to defang this prosecutor. He's out there saying, oh, all the guy can do is write a report, right? He can't indict us. He can just write a report. And, you know, I think we do have to hear from Mueller on this if he's 100% certain, because that changes his whole strategy. If the White House knows that this guy has decided they can't indict the president, then that will change a lot of their decisions about how they relate to Mueller.
Can I just say one thing? And I'm not a lawyer here, although I do play one, right? But neither Clinton nor Nixon were forced to participate in a criminal proceeding. Clinton was forced in a civil deposition, and Nixon was forced to produce the tapes, as we all know. So this has not yet been challenged, as you point out.
That's true, but the Supreme Court, and I'm glad you pointed that out, the Supreme Court was very clear on Clinton versus Jones. You did great, Gloria. You did really great. Holiday Inn last night, I knew it. It's very clear that if the court would find that it's necessary for you to still stand and be a part of a civil suit, courts notoriously look at criminal cases as a much higher gravitas assigned to him. So, but the real thing here that Giuliani is getting wrong, among a variety of things, is he's conflating whether you can stand for a criminal trial, whether you can indict a sitting president, whether one is indictable, and then whether you can subpoena him. These are all very different and distinct legal concepts. And and I think it's probably true that he made that statement, but existing policy in OLC is not binding or written in stone. It's binding until it's no longer binding. But it never changes the inquiry. If you can indict a president, one can always be subpoenaed. If not, there'd be no purpose for a grand jury.
All right, you know, David Swerdling, you did go to law school, so you've got some knowledge about this. Back in 1998, Rudy Giuliani was asked if a president is asked to testify, subpoenaed to testify before a grand jury and says, no, not going to do it. That was the question. Giuliani says, you got to do it. I mean, you don't have a choice. So at least in 1998, during the Bill Clinton uproar, he said if a president is subpoenaed, he's got to answer questions.
Sure, it really depends on which side of the political coin you're on. And as everybody has said, you can find a legal opinion within the Department of Justice to support whichever way you want to go. A couple of points here. One, right. The president's legal team wants to get this message out there that all that the special prosecutor can do is issue a report, but that's by statute what they are supposed to do. It goes to the Deputy Attorney General. Deputy Attorney General then should send it on to Congress. Second, I agree totally with you, Gloria, that Rudy Giuliani is trying to make this bank shot legal argument and get it out there in the atmosphere that if you can't be if you can't be indicted as a sitting president, then therefore, what is the legal point of you even being able to be subpoenaed to testify? I heard our colleague Ann Milgram last night make a very important point, which was actually that should be more incentive that the president should have to testify because then the legal pressure is off. He's just a witness, not a defendant in that case. So, of course, subpoena him, hear what information he can provide to the case.
So say he wanted to assert, here I go sounding like a lawyer again, say he wanted to assert the Fifth, then I can say you can't self-incriminate because we're not going to indict you. So how can you assert the Fifth? How can you take the Fifth here? That's another possibility.
There's so many, and that's part of the issue here about the strategy of the PR campaign, the court of public opinion, trying to meet the court of law. And I think Giuliani is crossing that road too many times in a way that undermines his credibility, because if all of these things are true and all the best case scenarios you've just laid out are true, then there is not the legal exposure. It would be as if you could say, if I'm an eyewitness to a homicide, well, I then can't be subpoenaed because I couldn't ultimately be indicted for that homicide. It would be completely nonsensical, but Giuliani tries nonetheless.
Very quickly, Ryan, yesterday the FBI director, Christopher Wray, tells Congress there is no witch hunt. It's not a witch hunt, the Russia probe. Today, the president doesn't only say it's a witch hunt, he says it's a disgusting, illegal, and unwarranted witch hunt.
Well, I mean, I think what Trump is doing and what Rudy are doing is basically the same thing, is that they know that at the end of the day, especially if they really believe that he cannot be indicted, that at the end of the day, the only remedy if Trump did something illegal or a high crime and misdemeanor is impeachment. And they know that this is now going to be in the realm of politics, and they need to supply their political allies with arguments about why, one, this investigation is, as they say, a witch hunt, and two, he didn't do anything wrong. And I think if Mueller's really decided that, that's where we're headed, right? We're headed into strictly the political realm of, does Congress step forward and do something with Mueller's findings?
Guys, thanks very much. You're not a lawyer. You're not a lawyer. We've learned you are a lawyer.
Only on the sit room.
Keeping score.
We're all
over
lawyers
here.
now in this administration.
I'm going to law school now, I think.
Not a bad idea. All right, guys, thanks very, very much.